Meaning of winding up. Winding up is a process whereby the life of a company is ended and property is administered for the benefit of shareholders and creditors. Modes of winding up of a company. According to Section 270 of the Companies Act 2013, a company can be wound up in two ways. They are the compulsory winding up of a company by tribunal or voluntarily winding up of a company. Compulsory winding up of a company by tribunal. According to Section 271 of a Companies Act, a tribunal may issue an order to wind up a company in the following circumstances: when the company is sick, where there is a special proposal, where the acts are against the state, when there is a fraudulent conduct of business, where there is a failure to file a financial statements with the registrar, and when it is just and equitable to wind up. Who can file a petition? The following individuals are entitled to file this petition: the company, any creditor or creditors, including any contingent or potential creditors, any contributors to that company, the registrar, and any person authorized by the central government to do so. Procedure for winding up. Appointment of liquidator to the company under Section 275 to examine the company's debts and credits in order to verify the company's eligibility for forced winding up by the tribunal. After the appointment of liquidators, as per Section 281 of the Act, the report is made to the tribunal. Tribunal issues orders to the liquidators in dissolving the company under Section 282 of the Act, and according to which the company's property undergoes shift into the custody in order to satisfy the creditors and contributors first. Finally, the court issues the order for dissolution under Section 302 of the Act after carefully reviewing the audits and reports provided by the liquidator to the court in the interest of resolving the obligations owed to creditors and other contributors. Voluntarily winding up of the company. Section 304 of the Act specifies two statutory conditions in which a company may be voluntarily wind up. If the company's general meeting approves a resolution requiring the company to be wind up voluntarily as a consequence of the expiration of the time for its duration, if any, as per its articles, or the occurrence of any event for which the articles prescribe that the company may be dissolved, or if the board of the directors approves a special resolution requesting that the firm is wind up voluntarily. Procedure for voluntarily winding up of a company. Convene a board meeting with the directors and approves a resolution with the statement by the directors that they have inquired into the accounts of the business and that the company has no obligations or that company will pay from the proceeds of the assets sold in the voluntarily winding up of the company. Notices calling for the general meeting of the company proposing the resolutions should be in writing, in addition with the relevant explanatory statement. Pass the ordinary resolution for the company's winding up by a simple majority in the general meeting or the exceptional resolution by 3/4 majority. The company's liquidation will begin on the date of the resolution. A creditors' meeting should take place on the same day or following day after the resolution to wind up passes. If 2/3 of the creditors agrees that the winding up the company is in the best interest of all the stakeholders, the company can be wind up voluntarily. A notification for the appointment of liquidator must be filed with the registrar within 10 days after passing the resolution for company's winding up. Certified copies of the ordinary or extraordinary resolutions passed at the company's general meeting for winding up must be sent within 30 days after the meeting. The company's affairs must be subject to wind up and the liquidator's account of the winding up account should be prepared and audited. When the company's affairs have been entirely wound up and it is going to be dissolved, a specific resolution should be enacted to dispose of company's books and documents. Within 2 weeks following the company's general meeting, the applicant may file a copy of the accounts and an application to the tribunal for an order of dissolution. Within 60 days after receiving the application, the tribunal must issue an order dissolving the firm. The company's liquidator must file the copy of the order with the registrar. After obtaining the copy of the tribunal's ruling, the registrar will issue a notice in the official gazette. This takes place to indicate the status of the company.